Welcome back to another episode of Tax Planning. If you don't know yet, one of the things Ashley and I love to follow are the ERC cases out there. And not just the so-called refund cases, pretty much wherever ERC pops up in the dockets, we are looking. And for some time now, a name in the dockets that keeps appearing, whether as plaintiff or as a defendant, is ERC Specialist LLC. Well, at the end of last month, a RICO claim was filed alleging that ERC Specialist LLC and its principals fraudulently inflated ERC claims. It also alleged violations of Utah's Truth in Advertising Deceptive Trade Practices statute. It's a fascinating case and tax planners and questions. So we are thrilled to be joined on this episode by plaintiff's counsel, Janine Campanero, and her associate, Jacob Langley.
Janine, do you want to give us a little introduction about yourself and Jacob, and one of you guys can tell us a little bit about your firm?
Sure. So my name is Janine Campanero. I am a senior litigation attorney with Zerby Miller, Fingerette, Frank, and Jadev. That's a mouthful, we know. So it's ZMF. Jacob Langley is an associate litigation attorney here also at ZMF. Jacob, if you want to introduce yourself.
Yeah, my name is Jacob Langley. I'm a litigation attorney here at ZMF, and I have been into this ERC space, I would say, for probably the better half of a couple years now and just following along. So thank y'all for having us today.
Yeah, just a little bit about our firm. We're located here in Houston. We represent small, medium-sized businesses and individuals all over the country. ZMF does specialize in the tax litigation world, not necessarily just ERC. We do a lot of other specialized credit litigation, but we are courtroom attorneys. We have represented clients in tax court, federal court, in the R&D space, 179D, captive insurance. So kind of the gamut. And ERC obviously is emerging as a big area in tax law that seems to be heading to the courtroom. So here we are.
So, Jacob, you said you've been working in the ERC space for a couple of years now in some fashion. How did you get started in it?
Yeah, so just as the case that we'll talk about here in a few minutes, we get clients referred to us by a variety of sources, primarily CPAs who want a second opinion and evaluation on whether the business's eligibility conforms with what the IRS has put forth. We know that it's a very complicated tax credit, and over the past few years, the legislation has really evolved in this space. So with that ever-changing environment and trying to stay up to date on the code, what our job is whenever a client is referred to us for the second review, that we determine whether or not this previous provider conformed with the eligibility requirements set forth by the Internal Revenue Service.
Interesting. So has your firm handled any or filed any suits more like refund litigation, or has it primarily involved taxpayers versus promoters, essentially?
Yeah, so the ERC space has been a little bit unique for us. Most of our litigation is either against the IRS or the DOJ, not usually private entities. And the ERC space thus far, it has just been more commercial litigation revolving around contracts that were entered into by our clients with private entities. We anticipate that the refund suits are coming, but we're trying to be patient and see the IRS's review and before we go ahead and file. Like Jacob said, our involvement has been to give a second look that various providers have done the ERC work for our clients and try and resolve any issues that occur pre-litigation. Litigation is never the first choice of any client, but here we are.
Okay.
Yeah.
Awesome. Well, I think that is a good segue for us to jump into this case, and I will go ahead and share it on my screen so that we can all look at it together. But we would love to get your thoughts from your perspective and your client's perspective on the allegations against this particular promoter. I'm curious to hear if you're seeing some commonalities among all of these cases that other taxpayers might identify with as well. So let me get that shared here. You guys see my screen?
Yes.
Janine or Jacob, do you guys want to give us a high-level overview of what the case is about?
Sure. So just some initial background information. Our client, who is a quality Telecom Consultants, Inc. was referred to ERC specialist for an evaluation of their eligibility for the employer retention tax credit. They signed this in the spring of 2023 is when they engaged with the ERC specialist, and they were subsequently qualified for a total credit amount of $2,972,055.91. And this would have been covering the three quarters of 2021, Q1, Q2, and Q3. As a result of that analysis and that eligibility determination, my client elected to pay 10% upfront as opposed to the 15% following receipt of credit amount. So to date, our client has paid $297,000 to ERC specialists in consideration of the study and analysis that was done. And just an overview of our client, Quality Telecom, they're a diverse general contractor. They specialize in telecommunications along with commercial construction, electrical, and steel building services. And they are based in California. Sometime after they were qualified, they paid ERC specialist. A new CFO started at our client who had experience in ERC. She was taking a look at all this and said, there's not much substantiation here. So after that, she reached out to ERC specialist requesting substantiation, more information about how they arrived at this qualification analysis, and was refused any additional information. Sometime after that, they were referred to our office where we took a second look and took a look at what the little work product that they did have and provided our client with our opinion.
So from the client's perspective, I'm curious to hear, as far as their experience, were they led to believe that it was an easy process? For example, I know I've heard things like some promoters were saying everyone qualifies, or did you experience supply chain issues, difficulty getting supplies, things like that? I'm just curious from their perspective, in the event there are others out there, and I know there are, who had a similar experience that may be now dealing with having received a credit that they don't qualify for.
Yeah. So with this client and with a lot of clients who I'm going to make it more general and say the pop-up ERC shops, this client had the same experience that many people did. First of all, they go to a website, they fill out a simplified questionnaire. It is intimated to them that this is a pretty easy process. Everyone qualifies, hurry up, the money's going to run out, that kind of stuff. It was the common theme of the ERC pop-up shops. It's a very bare bones questionnaire. Did you lose money? Were your services interrupted? Something as plain as that, which everybody in COVID, of course, their services were interrupted. The world was very different. It affected everybody. And it's those simple kinds of questions that were asked and responded to that seemed, and were led to believe, our client was led to believe that that qualified them for these credits.
If I'm reading the complaint correctly, they're also being led to believe, I think significantly here, that there's a complexity involved for which ERC specialists allegedly are the ones up to doing that, to being able to do that. And so you should not be, for instance, your CPA's guinea pig. You should use ERC specialists. Am I right reading it that way?
Absolutely. These are common themes that we see. It's highlighted specifically in our complaint. No need to be the guinea pig for your CPA. There's an allusion to CPAs are busy. The tax code is huge. This is what we specialize in. We're going to know better how to do this. They're too busy. Don't bother them. They're not focused on this like we are. I believe there's some of the common themes, or can't think of the word right now. Some of the comparisons is, going to your family doctor versus your specialist, your neurologist, the implications.
Generalist. Yeah.
Generalist versus specialized doctor.
Sure.
So those kinds of misleading statements were definitely present. I would say that the advertising or the way that providers are holding themselves out seem to have an influence on clients' decisions going forward in filing the credit.
Yeah.
One reason I wanted to ask about how it was presented to them is Can you talk a little bit about why this particular venue or jurisdiction was chosen for this complaint? Utah has some unique aspects, I think, specifically, which speak to some of the allegations here regarding the advertising.
Sure. So Utah is the primary place of business for the defendant, and we believe where most of the individually named defendants or principals of ERC specialists is also located. So they also have a centralized federal district court system, meaning if you look in Texas where we are in Houston, there's 4 different federal district courts. Utah has one, and so it all gets filtered and processed through the same court. But we did it in Utah, 1, because that's where the defendant is located, 2, because of the way their federal system is set up, and then 3, because they have some interesting state laws that really do allow and tie into our federal RICO claim. That way, the federal court obviously has subject matter jurisdiction over the RICO claim, but would also have subject matter jurisdiction over the state claim is because they're so closely tied into the RICO claim.
Okay. And on the RICO claim point specifically, I think that's a really interesting aspect to this case. And one reason we wanted to talk to you guys about it. I don't recall, Mary, you might know if there were any, and I'm sure Janine and Jacob, you guys know if there have been any others in the ERC space or even other tax credit suits that cite RICO allegations. Okay.
I do think there have been. I could be wrong, so correct me if I am, but I didn't list them out for our presentation today. So I don't want to name one and be wrong, but I do think I've run into a couple actually implicating RICO. What, Janine or Jacob, do you know?
I believe we've come across 1 or 2 that
Yeah.
have filed under RICO.
For
Yeah.
ERC specifically or in
Yes.
other.
Correct. And against a promoter as well.
Yes.
Okay. That is starting to sound a little familiar.
One of the reasons I also thought this case was particularly interesting is because it reminded me of it's the same defendant involved with the case out of Cook County, Illinois, that implicate the class action. And I think that's really interesting because here we don't see class action. We don't see permissive joinder going on. So that's something if either Janine or Jacob wants to say anything about, I'm interested in.
We definitely floated, had the conversation of class action a couple times. Not what we do, so it's not something we're overly familiar with. One of the reasons we decided against it is because any clients that we have with this provider or any other claims that could have been pulled into a class all revolve around different contracts at different times, and the contracts changed throughout the time. So there's definitely claims and damages that are similar amongst all plaintiffs. But right now, 1, we were only ready to move forward with 1 plaintiff, and 2, any other suits that may or may not be brought were based on different contracts containing different terms, which might change our underlying facts. Also, they were referred through different methods to ERC specialists. In this case, in other cases, they might have different affiliates that referred them. So different parties involved or additional parties involved, which you can tell by the way we filed this case. We're anticipating anyway. We did that row corporations to reserve the ability to add any additional companies or people in anticipation that we might find out more or additional defendants that might need to be added to this suit.
Sounds like you already anticipate that happening, most
Yes.
likely.
We do anticipate that is a likelihood.
Yeah. Okay. Yeah, it's interesting how ERC, it's almost like there are tentacles with it in not only how many industries and different areas of the law that it's impacting now on the back end, but we saw people and professionals get involved on the front end and selling and marketing and referring and promoting that had never been in this space before, which is really interesting. And I think it's just the whole thing, obviously, I think we all agree is unprecedented from so many angles. And I think we're going to learn more and more about this entire process and almost industry that was created around this one tax credit.
Jacob and I, and Jacob can confirm this, we spent many nights sitting here thinking we're going to work on, looking into one thing for a half hour, and 6 hours later, we're down this spider web, still sitting in front of the computer, finding videos and connections and, of just pop up ERC specialists who I know what I'm doing. Call me, like you put, Ashley, there's tentacles everywhere. Instead of it being an 8-legged octopus, it's like 100 different tentacles everywhere. And they all seem to connect to promoters.
I think it's a kraken. Is that the one?
Yeah,
Kraken.
Yeah.
I was going to say jellyfish, but I
Kraken.
like Kraken better.
I love kraken.
Yeah.
Yes, sir. Yeah. That's the one that worked for me anyway. Yeah.
I like Kraken.
Yeah, you heard it here. So
Yeah.
I get, there's probably the joinder issue or class or however that works. Maybe risk of if they didn't arise out of the same precise set of circumstances, gets dismissed or whatever. It's not my area, but I'm assuming that's kind of what you were going for. So similarly, what are some of the plausible defenses to what you have filed here that you're anticipating? What do you think you're at risk of facing right now?
That's a great question. I am very interested to see what the response is going to be. I honestly can't anticipate what will be in that answer, but I'm excited to see. Jacob, any thoughts on that? I really don't know.
I'm not really sure what may come out of the woodworks. I'm certainly curious as to what they come back with. Obviously, there's a number of people named here, so we may get a variety of very artful arguments as to number one, why the causes of action should not prevail, or jurisdiction or venue. So I think Janine and I are just waiting patiently to see what's filed in response.
Thanks. Yeah.
Yeah, it's going to be really interesting. Backing up just a little bit to the substance, and maybe we talked about this and I missed it, but your clients, they already received their checks, right? And then they essentially returned those to the IRS because they found out that they don't believe they qualified.
Yeah, that's correct. So again, just looking back, they were qualified for Q1 through 3 of 2021. They did receive checks for Q2 and Q3, to which they had already cashed. Upon electing that they do not qualify, they went through the withdrawal process for Q1, which is the quarter in which they did not receive a check. And then for Q2 and Q3 is whenever the IRS opened up the voluntary disclosure program, which they were able to apply to and subsequently accepted.
Okay. That's really interesting that Q2 and Q3, especially Q3, was paid out before Q1.
Really
The
interesting.
credit of this size. And I think Mary probably knows where I'm going with this, but that speaks to, it's an interesting glimpse into maybe how the IRS was processing these. And maybe they're, I know they've changed quite a few things since your client received their checks, but we've been told repeatedly that they were identifying low risk claims and quarters that likely were to qualify. And then those that were unlikely to qualify maybe would get some more scrutiny. But a Q3 claim, that alone is sort of, there's a better chance, I guess I'm trying to say, that it would not be eligible for Q3. And there were definitely some claims out there that are eligible for Q3, but it's just that sort of would have been an easy identifier, I think, for the IRS to use a cutoff of like, hey, we're not paying anything past Q2 of 21 just to be on the safe side.
I think this is part of what's so interesting about this complaint, or part of what caught my attention. I mean, from everything like you just said, Ashley, that we're seeing certainly in the last few months, but just sort of what we've had in our minds as disallowances and all these things have been coming out. It's that anything supply chain, anything Q3, anything super high dollar, like red flag, red flag, red flag. So yeah, I think you're right, Ash. I think this is one of the most interesting parts about this. It's just not what we would have expected for those reasons.
Yeah.
They got their money. That's pretty amazing.
Yeah, absolutely. And the red flags that you're talking about is the same reason that the hairs on the back of the neck of the new CFO was like, wait, what's going on? Let me see. And we're lucky that our client had that insight.
Yeah. also interesting. So you say they went through the withdrawal or the VDP?
For quarter one, in which they did not receive a check, they went through the withdrawal process. But for Q2 and Q3, since they had already received those funds and cashed those checks, they did apply for the voluntary disclosure program for those 2 quarters.
So Ashley, like, right? They actually get to keep a percentage of this. Like the IRS let this go through. Their
Yep.
analytics didn't do anything, and they're able now to report to us. In fact, it favors them in a way. Like fraud is rampant, and we're losing money. Well, this was a clear. This should have been caught right in the fun.
Yeah.
It's really interesting. Yeah.
And
Absolutely.
Janine, correct me on this, but just kind of going back to that disruption of supply chain argument. I mean, that's our basic assumption based on what the work product is that we had. We didn't really have much to go off of. Our best guess is that they were qualified under supply chain disruption. I mean, to date, Janine and I still have not had many documents to go off of, but what we do have, that's kind of what it points to.
And Mary, you bring up an excellent point, and that's part of the reason why litigation like this is important, because when these pop-up shops are doing it and somehow sneaking by, right, it gives credence to the IRS rhetoric that
Right.
fraud is rampant. This is false claims, all this, and our firm really doesn't believe that. We think there's a lot of taxpayers who applied for this credit, qualified for this credit. It helped small businesses. It was doing what it was supposed to. But these pop-up shops generating these kind of credits and things like this happening really allow substantiation to those claims. And it's disappointing. And it hurts taxpayers all around. I mean, not only is litigation, ultimately paid by taxpayer dollars, but it also prevents the taxpayers in that queue from quick processing of their claims. So
Yeah. Great points. Yeah.
I'm gonna kind of take a different path here just for, I guess, the sake of argument and maybe for entertainment purposes. And this may be way out there, but I'm just thinking through from the perspective of the promoter, not giving any credit necessarily to ERC specialists in particular, but just in general. If I'm a promoter and I am named in a lawsuit like this, the way that I'm going to try to defend it is to defend my processes, my work product, and try to essentially prove that almost like truth is a defense in a way that, no, look, this taxpayer was eligible. And I'm not saying this is the case. I'm just sort of at the other side a little bit in some of the defenses they might raise that, let's say they did have some information that based on the guidance and the law demonstrated that this was an eligible employer for 1, 2, or even all 3 quarters, which I don't think Q3 is on the table at all in this scenario, but just to pretend a little bit for the sake of argument, do you guys think that that could possibly be a defense in a case like this, just in general, maybe not this specific case, but if it turns out that, yeah, and I guess the reason I'm going down this path is there are a lot of taxpayers that took the credit. Maybe they didn't have they didn't get a great service from the promoter. Maybe the promoter is not even in existence anymore. They're not getting phone calls returned or inquiries returned when they ask for documentation about their credit or their claim. And then with all the negative publicity and kind of scare tactics by the IRS, it's leading some eligible employers to go down the path of VDP potentially and say, you know what, this is scaring me. I don't know if I qualified. And so I guess that's just sort of one other angle that I want to explore, is that if it's possible that there are some of these cases where the promoter might be able to say, look, here's where we vetted it, here's where they did qualify. And if that's the case, then what happens?
So that's kind of the point of the allegations we made in the complaint, right? Regardless of, in this hypothetical world where if they actually did qualify again, our client has had a second analysis, but let's say that they did, It doesn't change the deceptive advertising. It doesn't change the lack of substantiation. It doesn't change the statements made in these pop-up shop advertisings. Even your scenario, Ashley, when you're talking about maybe they did qualify, but now they're not being responsive and they're not helping and the taxpayer's nervous. That's really unfortunate for the taxpayer, because I'm sure there are companies out there that do qualify, but just had the wrong company qualify them. But the way you advertise, you're promising a service and you're promising a level of service and you're dealing with the government. I mean, you're submitting these forms under oath. You're submitting them to a government agency. So if you're doing that type of work and you're making these promises and you're holding yourself out in a certain light, then when your client comes to you, or when a taxpayer comes to you with concerns, I'm not saying giving away, don't give away your trade secret, don't give away your work product, but you should be able to provide enough substantiation either to quell the concerns of the taxpayer or to address any concerns that the IRS must face. I mean, you guys know as well as we do, the IRS is not going to sit there with the taxpayer and say, okay, well, send me your gross receipts, send me your business information, and maybe we can figure out how you qualify together. Like, they're not doing that with taxpayers, right? So if they did hire somebody who's no longer supporting them, no longer providing the substantiation needed, no longer helping them ask questions that the IRS is asking, or at least not providing enough information where someone like our firm can answer those questions that the IRS is asking, then there's still a problem there, whether or not they qualify. And they're certainly under the contracts that we're seeing aren't providing the services that they contracted to provide. So,
Yeah. No, that's a good point. The additional allegations you guys have layered in, rightfully so, in this complaint really provides a complexity that is, in this particular case, would be hard, I think, to defend, honestly.
Yeah.
Very interesting. So the allegation, the defendants claimed they had specialized knowledge and skill set to conduct this analysis and calculate the credit and claim it for the client. Is there any evidence that you have thus far that they did have people on staff, or was there someone signing the returns even that was a CPA, or I think someone was a certified payroll professional, which I'm not even
Right. Because this is a good point, because Ashley, where was it? You picked up on this on a read with just the two of us earlier, the accounting standards. I think that's an important point, just to find, because I'm not sure I completely understand it. Like that part, there you go.
right here. The willfully disregarded the standard of care for accountancy.
Thanks.
So I guess I'm curious, what brings them under that standard of care? I think we all agree that all of these promoters and anyone calculating a complicated tax credit for a taxpayer should come under the purview of CERC 230. And in fact, after the fact, the Office of Professional Responsibility has specifically said if you assist with ERC, you are under the purview of CERC 230. But rewinding back to when this claim was filed, I assume an ERC specialist is probably of the position or thought that they didn't have to follow the standard of care for accountancy that you mentioned here. So I'm curious, from the plaintiff's perspective, what brings them to that standard?
So in general, we're not going to go into specifics of what we have, what we don't have. We still have lengthy discovery and want to give them a chance to respond. But in general, when a client is reading advertisements and is being reassured that you are better at this than your CPA, you don't need to talk to them. We've qualified people that a CPA hasn't. This is what we do. When they file on their behalf, it definitely brings them under a standard of care for accountancy when you're holding yourself out to be that. Whether or not there's a little disclaimer at the bottom of some page that most people are not going to read, if you're holding yourself out and the conversations are consistently use us, don't use them, I would say that you're encompassed in that standard of care.
Yeah, that's a good point.
Thanks.
It sort of brings in the unauthorized practice of law, Mary, that you're always astutely pointing out. It's like perception is reality. It's a lot of the analysis on things like this is what was the perspective of the individual or a business that was harmed, essentially. Did they believe that they were dealing with a specialist, or in the case of UPL, an attorney?
Yeah. And could you have put like UPL in here? I mean, maybe that's where some claims need to go too, right? Like hit these UPL statutes.
Yeah, I mean, I think it's a great comparison. There's always this
Not
little
right,
in my mind
yeah.
when you're looking at it. Yeah.
Actually, now it's my pet peeve. Yeah.
Mary loves to cry UPL.
I do.
Yeah. I love this discussion. This case on its face, it came out, it was like, okay, here's another case and we'll digest it. But then once Mary and I started digging in, it was clear this one was very different from most of the others that have been filed. And I think there are a lot of things in here that are going to take ERC litigation just probably in on a different path because of the work that you're doing here. So I find it very interesting and really appreciate you guys being willing to answer our questions and kind of be in the hot seat for a minute on this.
Yeah. Everything Ashley just said. Thank you.
Well, we really appreciate you having us, and we're lucky to have a great team here. Jacob and I obviously are the two attorneys working on it, but we have some staff and some support that just care passionately about what's happening to our clients. So it's a team effort. I hope you're right. I hope it does start influencing ERC litigation a little bit. And obviously, if anybody has any questions or if you guys want to talk to us again as more things come out, we're happy to have that conversation. So
Yeah, and just to piggyback on that, I mean, also having a great client as well. I mean, obviously, them engaging with this company in spring of 23, this process has been a year and a half down the road. And, we could just be getting started here with the of this lawsuit. It's been a roller coaster for them from saying you do qualify. So now you're remedying your tax position with the IRS. You're trying to negotiate with this company who you pay, almost $300,000 to, who just won't budge. So, props to them for, sticking with us through this process. And hopefully at the end of the day, we'll achieve a good result.
Absolutely.
Well, I think that's a wrap. I don't have a closing
think that's
statement.
great.
I don't know if you want to. Yeah. But I do. I hope you guys will keep us posted. We'll be following. I don't know. Anything else, Ashley?
I don't think so. Maybe, some time goes by. Maybe we could do a little
Follow-up.
guinea pig
Yeah.
case update.
absolutely.
All right.
Absolutely.
Great.
Awesome.
Thanks.
Thanks, guys.